Welcome to Learn Short and Typing with Vikas Sir. Exercise number 20 and 21. 20 words at the rate 100 word per minute for your Punjab and Haryana High Court and all other courts. Be ready? Start. In the light of the fact that the conclusions arrived at by the courts below are based upon findings of fact recorded after appreciating the evidence on record in absence of any perversity or procedural illegality being pointed out, it cannot be stated that there is any legal infirmity in the impugned orders passed by the courts below. The learned advocate for the applicant is not in a position to disclose the findings of fact recorded by the courts below upon appreciation of evidence on record. Hence, in the light of the concurrent findings of fact recorded by the courts below, this court does not find any reason to interfere in exercise of revisional jurisdiction. It is accordingly not possible to hold that the courts below have erred in holding that the prosecution has successfully established the guilt of the applicant. Para. Insofar as the quantum of punishment is concerned, it is settled legal position that even at the appellate stage, it is permissible for the court to examine the quantum of the sentence awarded and in the facts and circumstances of the case to alter the same if it is so deems fit. In the facts of the present case, the applicant has been convicted for the offences under section 279, 304A, 337 and 338 of the Indian Penal Code and sections 177 and 184 of the Motor Vehicles Act. The maximum penalty for conviction of the offence under section 304A IPC is imprisonment of either description for a term which may extend to 2 years or with fine or with both. Whereas the punishment for the offence under section 338 IPC is imprisonment of either description for a term which may extend to 2 years or with fine which may extend to 1,000 rupees or with both. Thus, the maximum punishment envisaged under the said provisions is imprisonment for a period of 2 years, whereas the minimum could even be only fine. In the circumstances, considering the fact that a period of almost 17 years has elapsed since the date of the incident, and it has not been pointed out that the applicant has been involved in any other such incidents, this court is of the view that the quantum of punishment is required to be reduced. In the opinion of this court, the ends of justice would be met if the sentence of 2 years simple imprisonment is altered to a sentence of simple imprisonment for 1 year. Stop. Para. Insofar as the plea for granting the benefit or the provisions of the probation of Offenders Act 1958 is concerned on behalf of the applicant. Reliance has been placed upon the decision of the apex court in Paul George versus State of NCT of Delhi Supra, whereas the trial court has placed reliance upon the decision of the apex court in Dalbir Singh versus State of Haryana and others. Para. A per usual of both the above decisions shows that insofar as the decision in the case of Paul George versus State of NCT of Delhi is concerned, the apex court in the facts of the said case has, while dismissing the appeal, directed that the appellant therein be released on probation under section 4 of the Probation of Offenders Act 1958, considering the fact that the litigation had been going on for 20 years and that the applicant, who had a good career throughout but for this aberration, had been dismissed from the service on account of his conviction. However, the said decision does not lay down any principle of law as to under what circumstances probation can be granted under the provisions of the Probation of Offenders Act, whereas in the decision of the apex court in Dalbir Singh versus State of Haryana and others supra, on which reliance has been placed by the trial court while denying the benefit of provisions of the Probation of Offenders Act, the court has considered the provisions of section 4 of the said act in the light of the number of road accidents which are taking place in the country, and has held that while considering the quantum of sentence to be imposed for the offence of causing death by rush or negligent driving of automobiles, one of the prime considerations should be deterrence. The court held that, bearing in mind the galoping trend in road accidents in India and the devastating consequences visiting the victims and their families, criminal courts cannot treat the nature of the offence under section 304A IPC as attracting the benevolent provisions of section 4 of the Probation of Offenders Act. Para. In the light of the law laid down by the apex court in the said decision, it is apparent that the benefit of section 4 of the Probation of Offenders Act cannot be granted in relation to an offence under section 304A IPC. In the circumstances, the plea for grant of the benefit under the provisions of the Probation of Offenders Act cannot be accepted. Full stop. स्टूडेंट ये आपके 820 वर्ड्स है, इसको आप टाइप कीजिए, टाइप करने के बाद इसको आप मैच कीजिए। अगर आपको पीडीएफ चाहिए तो आपको डिस्क्रिप्शन बॉक्स में पीडीएफ आपको मिल जाएगी। और हम आपके लिए सीपीटी की क्लास कल वाली, कल हमने सेकंड क्लास डाली है, जिस बच्चे ने क्लास नहीं देखी है वहाँ पे जाके आप यूट्यूब में आपको मिल जाएगा सीपीटी क्लास बाय विकास सर। सेकंड क्लास है, आज आपकी थर्ड क्लास होगी, डेली की डेली आपकी क्लास होगी। और आपकी एडवांस एडवांस तरीके से आपकी क्लास होगी, आपके एडवांस फॉर्मूले होंगे, उससे नीचे ही आएगा, उससे ऊपर कभी नहीं आएगा, आज तक नहीं आया। या आपका एसएससी सीजीएल हो, पंजाब हरियाणा कोर्ट है, या कोई भी अदर डिपार्टमेंट हो, ये हमारा एक्सपीरियंस है। सीपीटी आपका आएगा नहीं इससे ऊपर जो हम यहाँ पे आपको करवाएंगे। ओके, थैंक यू वेरी मच, हैव ए गुड डे।